Honorable Minister for Revenue, Shri K. Rajan, eminent speakers, ladies and gentlemen. I shall be presenting a brief snapshot of the reforms in revenue matters, land matters, that the state has embarked upon since its inception. As part of the Keraleeyam celebrations, when we are projecting what is the best that Kerala has to present for the rest of the world, there's a lot that we have done with respect to land, that especially the Transformational Land Reforms Act of 1960, that is something that we would like to share and project. I'll present here a very brief snapshot, majorly on the Land Reforms Act, but also on the various other acts that whereby the whole idea of vesting citizens with rights to land, with ownership rights to land. What is it that the state has done? This government has been focusing on, and prior to this also, on three main pillars: Ellavarku Bhumi, Ella Bhumiyude Rekha, Ella Sevanangal Smart, which translates into land for all, records for all lands, and smart in all the services that we provide. So what we did start with, what the state did start with, just to give a brief background, prior to independence, we had land was essentially vested with the land belonging to the kings was essentially vested with the genmes and intermediaries who administered the land on behalf of the king and the landlords. There were cultivating tenants. However, these tenants had very limited rights. There were virtually no rights. They had no right to fixity of tenure. They had no right to the land itself. They had no right to the produce from the land, despite being cultivating tenants over there. And of course, there were agricultural landless laborers who also resided in some of these lands. So we have the cultivating tenants called the Kudiyans and the householders staying there, the Kudikadapakars, none of whom had any rights. So with the advent of independence, several efforts were taken by the then governments, the Travancore-Kochi government, as a precursor to the government of the state of Kerala once it was established as a state in 1956, to bring in some rights to show and break the feudal agrarian system. However, it had very limited effect because the focus was essentially on bringing in fixity of tenure rather than giving rights to the land, until the Transformational Kerala Land Reforms Act came in 1960. As a matter of fact, in 1961, the census report speaks about the per capita income of the state as in 1955-56 as 10.3%, less than the corresponding All India average. Compared to the rest of the nation, 40% of our population was dependent on agriculture, and yet only 17% were getting any kind of employment under the and income under agriculture. The average landholder holding size was 1.5 acres compared to the All India figure of 7.5. All of this without any rights to agriculturists and agricultural laborers, and the tenants obviously resulted in a lot of inequity and poverty. And therefore, as the Honorable Minister has already stated, in the late 1950s, 1957, 58, the move towards the Kerala agrarian reforms was started, and which, however, could not stand the test of the legal test, and therefore in 1960 the Kerala Land Reforms Act was brought in. Now, so the entire the entire focus of the Land Reforms Act was to bring in equity. It was to ensure that tenancy was abolished, that going beyond tenancy, fixity of tenure, the focus on bringing in rights of ownership to the land, rights to the produce, and therefore placing a ceiling or limit on the ownership of land, so that whatever is excess beyond the what the Genmi was allowed to own, that was handed over to, or through a process, handed over to the tenants for with absolute rights over the land. So the pillars of the Kerala Land Reforms Act essentially were about putting a ceiling on surplus, holding surplus land, declaring surplus, taking over the surplus land as vested in government, and distributing them to the tenants and other landless laborers. So essentially the whole idea was to move away from a system of landlordism that had been in force until then. I would like to take you through the process that that was followed, that was adopted by the Taluk land boards and the land tribunals. The reason this process is important is also for you to understand that despite the fact that when the late Shri Gauriyamma was presenting this in the assembly, and she talks about some 86,000 land holdings which would attract ceiling cases above, which have more than 15 acres of land, and some 13 lakh hectares, as I proceed with my presentation, you will see that we have not reached that many number of holdings or the total extent of land that has been declared as excess. Part of it is also because of this procedure that the Taluk Land Board follows and the land tribunals, where there is a process of the person filing, the declarant, the Genmi who is holding excess land filing ceiling return before the Taluk Land Board. And of course there was a suo motu provision for suo motu, taking suo motu cases by the TLB. Then the TLB publishes this draft statement. An individual notice as well as a public notice, hearing is conducted. It is a full quasi-judicial process that is followed, where evidence is adduced, and based on that evidence and whatever declarations that the declarant had to make and documents that the declarant produces, after all of those verification, the ceiling cases, the judgment is pronounced, and the statutory limit for families and individuals, which is all declared, which is all governed by provisions in the Act and the rules. So based on that, the ceiling is declared, the excess surplus land is declared with a proper survey sketch, and that is where the role of the Taluk Land Board subsides. And then the local Tehsildar takes over to take over comes into the picture to take over the excess land, and then the land tribunals for distribution of this excess land, and it is either distributed to landless families or to the vested for public purposes. Now, when you move to the land tribunals, which were supposed to be giving these rights vested in government through the purchase certificates, again it follows the same process, where a notice is issued. Both the Genmi and the tenant, they are presented before the tribunal, and they appear. And if the case is undisputed, the land tribunal goes ahead and delivers the verdict. And if it is disputed, again it is decided based on merits, with an authorized officer also coming into the picture and figuring out whether or not the declarations or the evidence that has been produced, or the statements that have been given by the the person in possession of the land and the land owners are taken into consideration, and based on that the necessary certificates are issued or assignment is done. Now, when you look at the impact, given this process has had kind of a dilatory effect in the sense that over the years, even now, we continue to have more than 70 years after this Transformational Act was enacted, more than 70 years after that, we still continue to have ceiling cases that remain unadjudicated, because again and again, even after the TLB has adjudicated, there is a provision for the declarant to, if the declarant is not happy with the judgment of the TLB, with the order of the TLB, to approach court and file CRPs, revision petitions before the courts, before the High Court. And so also government. If government is not happy with the decision of the TLB, even government can file a CRP. So this whole dilatory process has resulted in delays in taking over, in deciding sealing cases and taking over surplus land. Now, next. So as you can see, as this slide just reflects, now while we have given tenancy or rather title to 32.1 lakh tenants over the holdings through the land tribunals, it is nowhere near what was initially thought to be the initial thought process that went behind the Kerala Land Reforms Act. 52,218 sealing cases have been initiated, as against the 86,000 that was anticipated to be there. So this could possibly be due to an estimation, a wrong estimation, but also because we have missed a few cases for various reasons. And again, there are plantation cases where we have allowed them exemptions. 38,511 hectares of land has been taken as excess, and of which 27,268 have been distributed. Now, what happens to the rest of the land? So some land has been earmarked for public purpose, and yet these two figures don't add up to 38,000. This is also because much of the land that has been surrendered by the declarant is uninhabitable and cannot be used for any purpose. Also then, it would possibly include other sealing cases, the exemption cases that have come in. Now, of course, apart from the KLR Act, there have been a number of legislations, as the Honorable Minister has already pointed out in his, talked about in his address, about the various other legislations, reformative legislations that the state had enacted for assignment of land, for ensuring that everybody gets land. So every person has a piece of land, including, of course, several acts that acts and rules that were brought into place for abolition of minor tenancies, like, for instance, the Kandukrishi land assignment rules, the Shri the Shri Pandaravaka lands, the Kerala Private Forest Vesting and Enfranchisement Act. So there are several of these legislations that were brought in force to ensure that every person of the state, every citizen of the state has a parcel of land to his or her name, and which could be used for their economic upliftment. Now, it is a matter of pride for the state that much of this has, as a matter of fact, resulted in substantial reduction in poverty. I would like to put it that way, because right now Kerala is a state with the least poverty, and as reflected in the latest Niti Aayog figures, it has 0.55% of our total population is below poverty. Now, it has, as you can see, the distribution, this particular slide, we are talking about the distribution of purchase certificates to various tenants, as well as landless holders. We have, over the years, some 32 lakh tenants we have given certificates during this government. In the first 100 days, 13,514 purchase certificates have been issued. In the second 100 days, we have covered close to 34,000 certificates. And overall, in overall patayams, other than the land tribunal patayams, the overall patayams that we have issued during this period, corresponding period, is 57,674. Now, for the current year, we are targeting some 47,000, and as our district collector is sitting here would know that, and they've been working around this to achieve a target of 47,000 patayam under all, including the LT patayams. Again, as you see, the Taluk Land Board sealing cases, during the currently we have some 1,374 sealing cases, of which 83 have been disposed, and there are a balance of 1,291 to be disposed. The state has gone ahead and reorganized the taluk land boards into regional land boards to ensure that the deputy collectors in charge have full and 100% time to allot to this particular activity, so that we can complete all sealing cases at the earliest, and as the minister said, during the tenure of this ministry. That is the target. Now, this particular act has not been without its challenges, and here I'm talking about the Land Reforms Act. So the sealing area is not applicable in plantations. This was as part of, when the act itself was being debated in the assembly and brought about. So to ensure that plantations obviously can't be held in small parcels of land, and therefore to ensure that the rights of those landholders are not violated, sealing exemption provisions were given under various sections, under Section 81 of the Act. And now this, as we see, has become, over time, has been used as a tool to hold on to excess land, even when you are not using it as a plantation, unfortunately. There has been fragmentation of plantations. And as per the Act itself, whereas once it is fragmented, and because the Act provides for an exemption based on the use, and when the use changes, automatically the sealing, the exemption from the sealing is also withdrawn. It no longer applies. However, the Act also does not, the ownership of a plantation still vests with the owner, and it is not with government. There are no sealing provisions that have been given over there. And as a result, there have been fragmentation of plantations, and they have been sold and given away to other landholders. Many of them have purchased it and could possibly be very, very small, they could possibly be having small holdings, and which some of them have been regularized in 2005. We brought in the legislation whereby they were considered as deemed tenants, which is a little ironic considering that the Land Reforms Act itself was supposed to abolish tenancy. However, bringing in that provision, they were given rights to the land. But even so, we are well aware of cases in several places, especially in Kottayam, etc., where the revenue officers, because these have been fragmented lands transferred from plantation owners by violating the sealing limits, and or rather the exemption provisions. So there are areas where we have not allowed them to pay the basic tax. We have not done the mutation in their favor. So the state loses out in terms of generating revenue, and the owner, the actual owner who is holding the land now, is no longer an owner and does not have ownership rights still, despite the fact that he or she has procured the land from the original owner. So those challenges remain. The sealing provision, as I said, did not generate the kind of expected surplus that had been anticipated at the time of enactment of the Act. That is probably because we gave several exemptions based on the various provisions other than the plantation. It was also for educational purposes, for charitable institutions, purposes for religious institutions. So all of those exemptions have come in. And also the whole process is quite dilatory, as I said, and declarants have taken government to court, or the TLBs to court, rather, not the government, but the TLBs to court for the various orders that have been issued, and therefore it has gotten stuck in this whole process of solving it legally. Again, tribals engaged in shifting cultivation because they move from place to place. So to prove oral tenancies and then to give them protection under this particular act, it has not actually happened, and we have instead moved towards other provisions to provide some kind of fixity of rights for tribals, whether it is the under the Forest Rights Act or under the Kerala, the protection of or alienation of land of scheduled tribes. So that is what we have resorted to. The cost of cultivation, ironically, the cost of cultivation of paddy, or rather the cultivation of paddy itself, has seen a decline. The whole idea was, if you give ownership rights, the person who was once a tenant without any kind of fixity of tenure, without any rights, would invest in the land, would cultivate the land and ensure that over a period of time production goes up. Now this has not happened, unfortunately. As a matter of fact, we see that the land under cultivation has gone down. So, and finally, we have problems in terms of how do we, is this provision, are these the challenges moving forward, especially for an aspirational state which wants to launch itself and improve its economic profile and growth, though we are doing pretty well now. Despite that, if you are to see that kind of economic growth, what kind of are the ceiling provisions becoming are they creating a hurdle, a bottleneck for development? That is one area that we need to look at. Next. I will just quickly run through, since I'm running out of time, I will just quickly run through the rest of the slides. This is the distribution of patayams, which we have already talked of, in terms of both the land tribunal patayams as well as regular land assignment patayams over the period of 2016-21. Now the next, what have we done? Next patayam mission. So what have we done to resolve the hitches in terms of land assignment? How do you ensure that people who are entitled to these land actually do get their rights? And we have in terms of procedurally, the patayam dashboard has been put in place where we track and resolve all kinds of issues that may not be resolvable at the district level. So we are trying to work that out. Patayam assemblies to collect data from the field, directly from the field, with the help of local representatives, because they know it best, with the aim of solving issues to the best that we can. Next. And in ensuring, as we said, all services are easily available and easily accessible, and therefore the move towards the smart revenue offices, the smart village offices and revenue offices. And over this period of time, we have about, of the 1542 village offices, 567 have been made smart. Now when we say smart, it is to ensure that absolute, in terms of the infrastructure that is being provided in the revenue offices, in the village offices, as far as the citizen is concerned, it is smooth. It has a proper waiting area. It has, but much more importantly, also that all our services are made digital and accessible online to all our citizens. Next. This is about the e-governance initiatives that we have taken in the Revenue Department, where we have moved towards 100% e-office implementation, which ensures that there is a lot of accountability in the way we manage files, so that any kind of red tapeism, any kind of rent seeking that happens can be easily tracked. All offices have been equipped properly to take care of this. There are several features over here. We have the citizen-centric services, then we have the personnel-centric services, and then we have the collection services. So we have the land revenue information system, which many of you are aware of, and whereby the citizens, and of course the citizen e-services, the citizen has a one-point access to log on to this portal and get and track the delivery of these services that is being done. E-payment services, we have created the necessary provisions for e-payment, so that a citizen does not really need to come and to pay physically in cash or kind. So, and this is, all of this is to ensure that not only that the citizen gets ease of access to services, but also to ensure that there is limited interaction between officials and the citizens, which would prevent any kind of collusion, which is something that administration is generally prone to. Next. So this is just a snapshot of where we are in terms of e-office, with all our collectorates, RDO offices, taluk offices and village offices 100% connected. But there are some of our special offices which will definitely need to be covered over here. Next. These are the institutional arrangements for better revenue administration, so that starting from the level of the minister who holds these regular weekly revenue secretariat meetings to understand how do we go about solving solutions and procedures and simplifying them to move ahead and achieve our objectives. The Pataya Mission, Pataya Assembly, the Survey Jagrata Samiti, which my colleague over here, Shri Sambasiva Rao, will talk about in detail. Next. I will end with this particular slide. This is about, this is something again the Honorable Minister has touched upon, and which Sambasiva Rao will be talking about in detail. But it is about the digital survey initiative of Kerala, which we have started with a lot of fanfare, with a lot of, it's a very ambitious program, and we are well on our way to achieving it. So we are getting the survey department and the revenue department to work together towards this, this exercise. The biggest, the biggest service that we are looking at is essentially the integration of the revenue registration and the service department services. Even now, mutations are provided online. However, you need to do that sketch, and upload that a physical sketch, scan it, upload it, and then the mutation happens. The online mutation happens. However, and the kind of the linkage of all three, revenue, survey and registration, is not 100% complete, and this is where we are moving towards with the Ende Bhumi portal, an integrated portal that would ensure seamless delivery of services, and a citizen does not have to go again and again to the three departments for seeking mutation. We have, of course, where we talk about, we get the RELIS, the EMAP and PEARL to merge into this Ende Bhumi. I will leave that to Samba to talk about it. And the number of villages that we have already covered, we are trying to cover all our villages over the next 4 years, and we are well placed to reach this ambitious target. So it is with this that I will end my brief presentation on what the department is doing, and the kind of initiatives that the revenue sector has taken, land revenue sector has taken to make it, to ensure that all citizens in the state have access to a parcel of land and have the records to it. Thank you.